Good afternoon, everyone, and thank you for joining us for the Right of Publicity update. I'm going to get things started since my presentation is very brief. My name is Tessa Gray. I'm a third-year law student and also co-president of Howard University's Intellectual Property Students Association. I'm here to give an update on IPSA's position regarding current name, image, and likeness issues and actions we've taken to assert our position. IPSA believes that student athletes, like any other student at a university, has a right to profit off the image they've worked to curate. As many of you know, and as Mr. Katz informed me many weeks ago, the NCAA recently voted on name, image, and likeness regulations that were determined to be in violation of US antitrust laws. As an organization, we've become a lot more skeptical about the NCAA's ability to regulate fairly and in the interest of their student athletes, many of whom come from socioeconomically disadvantaged communities. As a result, IPSA has created a petition in support of Senator Murphy and Senator Trahan's bill called the College Athlete Economic Freedom Act, which purports to not only ban the NCAA from creating rules that interfere with these students' rights, but also provides a cause of action for student athletes to enforce their rights and imposes per se antitrust penalties against certain violations. This is the most student-friendly bill proposed thus far, so we've encouraged other students and organizations from other universities to support it as well. We've also drafted a letter to the NCAA directly. First, we saw athletic director support, but many were hesitant to speak out against the NCAA publicly. So as a result, we've decided to incorporate the support of intellectual property student associations and Black law student associations from universities across the country. In our written materials, you can view each of the documents I've referenced, including the College Athlete Economic Freedom Act itself. Obviously, IPSA will remain committed to this issue and finding spaces where we can help effectuate change, but we're also very pleased to see so many people advocating for these students, and we love hearing and learning from their perspectives. So with that, I'm going to pass it along to Mr. Ron Katz, who will briefly introduce himself and provide an update on his work in this area in the last year.
You're on mute.
Thank you, Tessa. I've had the pleasure of working with her for the past few weeks on this project, and I've had the pleasure of working with Professor Matima for the past, I don't know, 25 or 30 years, first in private practice and then with the IIPSJ. And I just want to commend him for the fabulous work that he's done. His vision and his hard work have really paid off. I understand that the program this year has 3 times as many people as it did last year. So I assume that's because Jonathan and I spoke last year, but I'm not sure. I haven't verified that yet. But in any event, I want to talk to you today about what really must be the most powerful and the most clever organization in the world, and that's the NCAA. And why are they so powerful? Why are they so clever? Because they have gotten us to talk about something that is total nonsense, to take seriously an idea that just makes no sense whatsoever. This should not even be a topic of conversation. We have something that controls names, images, and licenses. It's called the free market. We have something. It's called capitalism. May not be a perfect system, but that's the system we have. And I don't think the NCAA has really improved on that, with all due respect. Well, they have from their point of view, because they get all the money and the athletes get nothing. So, so what is it that's the problem here? I mean, when you think of all the things that you own, or even all the intellectual property that you own, even though there's no degree of ownership, really, is there anything that you own more than your own name, than your own image, than your own likeness? Really, this is the core of who you are. This is who you are. I mean, we can call it intellectual property. I guess we have to call it intellectual property because we're at an intellectual property conference. But that really understates it. This is your persona. So how is it that any organization, and in particular a sporting organization, how is it that a sporting organization can say, well, you really can't do anything with that name, image, and likeness unless we say so? Well, first of all, they said you can't do anything. Now they're saying, okay, well, we're going to make some hokey rules for you. And it just doesn't work. And it's crumbling. It's crumbling, and it will crumble. But the NCAA's been in business for a long time. They've taken a lot of money that should have gone to deserving athletes for a long time. So what is their position on name, image, and likeness? Well, if we look at the history is even more horrible than the present. In the history of it, they said basically you can't do anything with your name, image, and likeness. Sure, if you are a violin player on campus and you're very good at violin and you play with the New York Philharmonic or whatever it is and people want to use your picture, no problem. You can get as much money as you can make in a free market. But if you're an athlete, you cannot do that. So once upon a time, they just said you can't do anything. And then there was a lawsuit, the O'Bannon lawsuit, which I'll talk about a little bit more later. It's actually an antitrust lawsuit. And that lawsuit, the result of that lawsuit, years of litigation and appeals, was that athletes could profit from their name, image, and license, but only up to the cost of attendance of going to school, which, considering that they already got a scholarship, maybe it was $4,000 or $5,000 a year that they could make, but it was some very small amount, and it had to be tethered to education, because we all know that sports is like the most educational thing of all time. That's what universities really exist for, is to have sports. So that was the rule, and then it changed. And then the rule was so irrational that one of the famous cases involving the rule was called Bloom versus the NCAA. Well, Mr. Bloom went to the University of Colorado. He was a great athlete. He was not only a world-class skier, but he was also a football player. So what was the NCAA rule as it applied to Mr. Bloom? And I challenge anyone in this room or in the world to tell me why this makes sense. So they said, well, Mr. Bloom, you're a professional skier, but you don't do that in college. You just play football in college. So we're going to say that you can get your prize money as a professional skier. Okay, that was fine. But one of the great things about being a professional skier is that, and anybody who skis knows this, you have to buy hundreds and hundreds and maybe even thousands of dollars worth of equipment. You got to buy your skis and your poles and your parka, and trust me, it's thousands of dollars before you're through with it. So, of course, one of the ways that skiers make money is to give endorsements. Say, use Vocal skis, use this Patagonia parka. It's a very good source of income for them. So what was the NCAA rule? The NCAA rule was, well, you can make the prize money, but you can't endorse products. Now, how they drew that line, nobody knew, because they were the king. They were the absolute rulers at that time. This was in 2007. And I have the case right here. And the attitude of the courts at that time, which has changed, but this was the attitude of the courts at that time. I'm quoting from the case. NCAA decisions regarding challenges of student athletes are entitled to considerable deference, and courts are reluctant to replace the NCAA as the decision maker on these matters. So basically, whatever is right. They should have just looked back at the French Revolution. That's what Louis XIV said. Whatever is right. So they lost the O'Bannon case. And then another thing started happening is that people became more aware of injustice. They became more aware of the fact that college coaches make millions of dollars and the athletes make nothing. But nobody tunes in to watch the coaches. You tune in to watch the athletes. They're really generating the money. So the unfairness of this finally spread to state legislatures. And I'm proud to say that my state, California, was the first one to enact legislation and to say, you can't stop students from profiting from their name, image, and likeness. And that was in 2019. And they said, well, the law will go into effect in 2023, giving the NCAA some time. And then 9 or 10 other states did the same thing. None of them is in effect yet, but I think the first one, the Florida one, I think goes into effect this summer. So once that happened, the NCAA had a huge problem, because if you're a great athlete, why wouldn't you want, we have some very fine colleges out here in California. So do you want to go to Alabama, where you get 0 for your name, image, or likeness? Or would you prefer to go to USC, very fine football school, at least it used to be, fine football school, and you can make millions? Well, I don't know. I think I'd rather make millions. If I were I'm not an athlete, but if I were an athlete, I would rather just take the millions. So the NCAA had a real problem. And so after many, many years and much irrationality, they said, okay, we're going to change the rules and we're going to allow students to profit from their name, image, and likeness. And of course, the first thing they did, they appointed a committee. What else? You know, and we have a committee here, and the committee's going to think about this, and it's going to be great. It's all going to be great. And this actually happened last year at this time of this conference. And I don't want to pat myself on the back. Well, I will, of course. What I said at that time is, I don't know what this rule is going to be. I don't know what the rules are going to be, but I can tell you one thing. I can guarantee it. They're going to be horrible. They're going to be just terrible, terrible rules. And I was right. This past August, they came out with rules. And what did the rules say? Did the rules just say, God bless you, and go profit, you know, be fruitful and multiply, go profit from your name, image, and likeness, you're famous? I mean, because really, if you're the best quarterback in high school this year, if you're the top recruit, does it really matter whether you go to Alabama or USC or Notre Dame? You're going to be great wherever you go. It's not Alabama that's making you great. It's not USC that's making you great. It's you that's making you great. And does this cost the NCAA 1 penny? No. If I get money, if I'm a great athlete and I get money from Coca-Cola, say I drink Coke, it doesn't cost my university anything. It doesn't cost the NCAA a penny. So why are they doing this? They're doing it to preserve amateur. This is what I talked about last year, amateurism. But they have a problem. They can't define amateurism. Nobody knows what amateurism is. Amateurism is what they say amateurism is, and they said it in court, it's basically whatever the NCAA says it is. Well, that's what we call arbitrary. So these rules said, first of all, you can't just do this by yourself. Of course, you're just students. You know, even though that you've made a name for yourself and people want to pay you millions of dollars, you're just a stupid kid. So you need help. So we're going to create this bureau to give you help. And in fact, of course, the bureau has to know exactly what you're doing. So you have to report everything to them about what monies you're going to get for your name, image, and likeness. Well, guess what? Have they ever heard of confidentiality? When you're making a deal, Jonathan represents a lot of music people. When you're making a deal, you don't put it in the newspaper. You don't want your competitors, the other artists or the other players, to know how much you're getting. The company doesn't want other people to know how much they're paying. That's private information. But the NCAA says, well, we have to know that. And then another part of the rule is, well, you can't compete against your own college. So let's say your college has a deal with Adidas. You can't make a deal with Nike. Well, I mean, they couldn't tell Michael Jordan to do that. Michael Jordan I remember he had to cover up his uniform when he played in the Olympics. How is that? What kind of competition is that? We say, well, you can do everything except the best thing. We all know the best thing is shoes. Shoes is really where it's at. So, and of course, if I go to a college that's sponsored by Adidas, I can't make a deal with Adidas because Adidas already has a deal. They already own my college, lock, stock, and barrel. They're paying them tens of millions of dollars. So what do I have to, so what's my option? Well, I'll go to Nike, no problem. No, you can't go to Nike. And then the third rule that they've imposed in their wisdom, well, they haven't succeeded yet. The third rule is you can't do anything against the values of your college or the NCAA. Well, what are the values of your college? What are the values of the NCAA? I mean, well, the value of the NCAA is take all the money and give nobody else any money. You can't, I guess you could do that, but what it means really is, let's say that you wanted to endorse pot. Some pot grower asked you, in California, it's legal to smoke dope out here. So if somebody asked you to do that, you'd have to, and your college said that's against our policy. I don't know what colleges are saying about pot these days. I know when I go over to Stanford, I smell a lot of pot. I know that, but I don't know what the policy is. So basically, they say, well, you can't do that. Well, it's legal. It's legal here. Why are you telling me that I can't do something that's legal? Or what if somebody asked me if I'm over 21 and somebody asked me to endorse a light beer? You know, you might have seen 1 or 2 beer advertisements on television. It's a big deal. People make a lot of money from it. Well, no, alcohol is against our policy, so you can't do that. But then, of course, what if you just say, you know, I'd like to endorse free speech. Somebody's going to pay me the ACLU is going to pay me to endorse free. Well, I'm not so sure about that. You know, they could say anything. It's a total open-ended mess is basically what it is. So they enacted they didn't enact the rules. They proposed the rules. And I don't want to tell you my opinion of them. You'll have to guess that. But I can tell you what Senator Richard Blumenthal of Connecticut said about them. And he's an important person. He's a senator, and also he's the head of the committee that would make legislation on names, images, and likenesses. And he said that the proposal of the NCAA was functionally useless and, quote, will do little to change the current exploitive state of college athletics. So basically, you know, when you have a powerful senator against you, you've got some problems. And then at the very end of the Trump administration, the NCAA got a letter from the Antitrust Division, and the letter from the Antitrust Division said, oh, by the way, this violates the antitrust laws, because you're telling, you know, the athletes are competitors. You're basically telling them they can't compete. And this was at the very, very end of the Trump administration, although antitrust is not a hot button issue. And the guy who wrote the letter from the Antitrust Division said, oh, and by the way, even though it's the end of the Trump administration, I'm absolutely positive that the next administration will take the same position, because what you're doing is so blatant. You are, and what they're doing is something they've done before. It's not like they're strangers to antitrust law. In fact, they're recidivists. The big antitrust case back in the 80s, it's hard to imagine that there were only 3 college football games per week on TV then. You know, now if you want to watch college football at 3 o'clock in the morning on Thursday night, you can do it. But then the NCAA controlled everything, and they were very afraid. I mean, talk about stupid. They were afraid that the television would kill their cash cow, and their cash cow was gate receipts at that time. Well, how wrong were they? I mean, how many people could you put in Stanford Stadium? If you could put 55,000 people in Stanford Stadium and they all paid $100, that doesn't compare to ESPN paying you $3 billion. You know, it's just incredibly bad move on their part, but they lost. The Supreme Court said, you can't do this. You're telling college. They were sued by the University of Oklahoma, which is a big football school. And they said, we play a lot of good games, and we want to put a lot of our games on TV. We think it'll be a good thing for our team and for our program. And the court said, yeah, you can't stop somebody from offering things to customers. That's what our society is all about. You can't do that. You lose. This is the Supreme Court of the United States. And then about 20 years later, we had the O'Bannon case. And it was the same thing. They were saying you can't use your name, image, and likeness. And the court said, no, that violates the antitrust laws. But the court was still hung up on this idea that whatever the NCAA does relates to education. Well, look at the graduation rates. Do those relate to education? I just don't think so. I think sports is a if you turn on a football game and you don't know whether it's a college game or a pro game, you can't tell the difference. You really can't tell the difference. And the amount of money generated, it's about, they don't generate as much as the pros, but they generate billions and billions of dollars. And then there was another antitrust case after that having to do with paying the college students. And again, they said you have to pay them, but it's also restricted by the cost of attending. So we have this completely irrational situation. The NCAA is now completely in a box because they said they were going to come up with their program in January. January came and went, and they didn't come up with the program because the antitrust division warned them that it was an antitrust violation. And then Senator Blumenthal criticized and said, well, you said you were going to come up with something in January, and you didn't. So they were sort of between a rock and a hard place. I do think that this will eventually resolve itself, but my heart goes out to all the athletes who were not able to profit from who they are, their own name, image, and likeness. And I'll turn it over to my friend Jonathan.
Thanks, Ron. Hopefully everyone can hear me okay. Yes? Okay, great, wonderful. Pleasure to meet you or see you virtually, some of you anyway, and look forward to being back in person around this time next year. Fingers crossed. I want to pick up where Ron left off in terms of just the fact that what he is expressing, and certainly quite passionately, to say the least, is this growing crescendo of proponents of name, image, and likeness legislation, not just in the state of California, but we are starting to see other states slowly but surely attempt to implement similar legislation. And I think eventually we'll likely even see some sort of federal legislation that is proposed. But, why not go big or go home, right? Why don't we just have a federalized right of publicity law that includes a section regarding the NCAA or a section regarding specifically student athletes and their ability to earn endorsement deals off the field. So to me, it's a part of a larger systemic issue that is keeping the likes of me in business. I certainly don't mind it personally, but I do think that it's just a matter of time. It's a matter of when, not if. And Professor Ncaa, thank you again for inviting me. It's always a pleasure to be here as a class of 2002 graduate. And obviously our hearts and prayers and condolences go out to our 1960 alumnus, Vernon Jordan, who passed away just a few days ago. But I will say, Professor Ncaa, in terms of this name, image, and likeness agenda, I have not seen Donald Remy back at the law school lately. I don't know if he's in hiding, my fraternity brother is in hiding, or he's just really busy right now, and he's not been able to have the opportunity to come in and visit this passionate environment. So our panel topic is right of publicity law update. And so you've heard Ron give you the update from the sports perspective, and by far the name, image, and likeness and related legislation issues out of student athletes is the hot button or hot topic in terms of the sports industry. And what I'd like to do is complement that by giving you an entertainment related update from right of publicity law. So you have a very full, robust overview comprehensively as to what is happening with respect to right of publicity law. As you may know, I've had the opportunity to speak in the past about one of my cases I've worked on involving Curtis James Jackson versus William Roberts. Okay, fine. 50 Cent versus Rick Ross. Okay, now you know who I'm talking about, right? So Mr. Jackson had sued Mr. Roberts for a right of publicity violation for an unauthorized reproduction of the master recording of a song back in 2003 called In the Club. It was one of the top 100 songs of that year. It was one of the top 100 songs of that decade between 2000 and 2010. And even to date, it has been listed as one of the top 500 greatest songs in history. So In the Club, it was recorded and performed by Mr. Jackson back in 2003. He was subject to a work for hire recording artist agreement with Shady Aftermath, a joint record imprint label subsidiary of Jimmy Iovine's Interscope record. Universal Music then served as the distributor. And so fast forward about, over a decade later in 2015, December of 2015, Mr. Roberts releases a remix or mixtape album, something routinely done in the hip hop industry or the music industry, where musicians want to stay abreast of what is transpiring in between their commercially released albums. So he released a mixtape called the Renzel Remixes, and he had 26 songs on that mixtape album. And he remixed a lot of popular songs from that time frame, including Adele's Hello. He also remixed songs from Snoop Dogg to Lil Wayne to Kendrick Lamar to Nas. And one of those 26 songs happened to be 50 Cent's In the Club. And I think it would have been just fine in some ways, because after all, Mr. Roberts is an artist that has been signed to Universal Music Group, the same company that has an affiliation with Get Rich or Die Trying. But towards the end of that remix version, the last 20 seconds, his producer loops back in the hook or the chorus that is sung by Mr. Jackson. And it's the use of Mr. Jackson's voice at the very end of that remix that propelled him to then have the ability to have standing, if you will, to sue for a right of publicity violation. So his lawyers, I give them credit, very creative, and respectfully, it was a fair position to take. They realized they could not sue for copyright infringement because he did not own the rights contractually to the master recording of that song. So he was forced to sue for right of publicity violation. As we all know, with respect to copyright law, it's a statutory exclusive right. Key word here, exclusive. So he who holds the gold or he who holds the copyright registration is who gets to set the rules on who gets to then reproduce, display, redistribute, or have a derivative work of that copyrighted deposited work. And so because we have this existence under U.S. copyright law regarding exclusivity, so much so that it can actually even go so far as to preclude and trump, if you will, someone else's potential quote unquote right of publicity. And so the lower court, Judge Warren Eganton out of the U.S. District Court of Connecticut, granted summary judgment in my client's favor, preempting Mr. Jackson's ability to sue for right of publicity in light of his ownership issue with respect to the copyright for the song. So I fully admit that I won on a technicality. That happens sometimes. And what was interesting is the Second Circuit, U.S. Court of Appeals for the Second Circuit, because Mr. Jackson was not going to give up lightly. He challenged that district court order, and we had oral arguments in January of 2019. It was, I think, one of my last trips, I think, before this pandemic started. And in August of last year, the Second Circuit rendered its opinion, a 66-page opinion to be exact, in which they affirmed the lower court's ruling and continued to acknowledge this preemption doctrine of copyright law. So you can certainly ask the question, is there tension between right of publicity law and copyright law? And did this Second Circuit opinion reaffirm that? Yes, no question about it. And in fact, the Second Circuit, in affirming copyright preemption, barring Mr. Jackson's right of publicity claim, it now is actually consistent with the Eighth Circuit's Ray versus ESPN case, as well as the Ninth Circuit's Sony versus Laws case involving Jennifer Lopez. So while this does set precedent for the Second Circuit, it's never been done before, surprisingly, despite the fact that there are a number of TV, film, media, entertainment giants that are right there in New York and the surrounding tri-state area. This particular decision had not yet been decided. So it simply reaffirms and is consistent with at least a few other circuits. You contrast that with the Third Circuit Facenda case versus NFL Films, in which they wanted to create a carve-out exception in which they were suggesting that there should still be a right of publicity with the exception of certain commercial or advertising contexts. So at least the Third Circuit is acknowledging, yes, we acknowledge preemption, but there should be an exception to that. If you go so far as to still abuse or commercially exploit one's right of publicity in such a commercial manner, that should still have its own ability to stand, and it should not be preempted by copyright law. The problem here, as the court saw it, are contextual facts. And I pulled up just a few words from the Second Circuit in which they say there is no contextual implication of endorsement. And we know that endorsement is one of the elements of a right of publicity claim. You have to establish the identity element, you have to establish the misappropriation element, or that the person's name, image, or likeness has been misappropriated or commercially exploited or endorsed. And here the Second Circuit concluded there is no contextual implication of endorsement. Nothing in Robert's mixtape suggests Jackson's endorsement or sponsorship. Jackson does not appear on the cover of the mixtape, nor do any of Mr. Roberts' lyrics refer to Mr. Jackson, and nor is the Indie Club sample used in a manner that could mislead listeners into believing that it was new material that Jackson had created specifically for inclusion in Roberts' mixtape. And they also acknowledged that, you want some social justice context here about acknowledgement of African-American music. Here's what the Second Circuit said about that. The evidence is commonplace for hip hop artists to sample each other's songs without permission, including Mr. Jackson himself, who in the transcript and in the record clearly acknowledged that he himself had remixed a lot of different artists prior to him kind of making it big, if you will, including Michael Jackson's I'll Be There, including the Notorious B.I.G. as well. So there's a contextualized aspect to, I think, the way in which the Second Circuit rendered its ultimate position. And I'll also acknowledge that despite the fact that the court, oh, I'm sorry, let me make sure we're on the same page here about what preemption is. Okay, so copyright preemption, it will prevent a state equivalent right of publicity based on satisfying two elements. Number one, what you're asserting has to be basically within the Copyright Act itself. It has to be a type of work that is within the Copyright Act. So here we're talking about music. And we all know music is a musical work. Can also be a literary work, and it can also be a sound recording. These are all statutorily recognized copyright subject protectable works under the U.S. Copyright Act. So there's no question that what fact was at issue in my case was about a copyrighted work. And then you look at the second element of preemption, that is dealing with a right that is equivalent of what it is that you're trying to assert that's equally recognized under the Copyright Act. And they usually actually use the word equivalent element, or the equivalent second factor of preemption. So what the heck does that mean? Well, if it looks like a duck, if it walks like a duck, if it quacks like a duck, then it's a darn duck. And in other words, is it a disguised attempt at trying to assert a copyright infringement claim? And here we have that as well, because we're talking about the unauthorized reproduction of a musical work, of a sound recording. And so there was no question that Mr. Roberts took the same sound. If you were to play them side by side, it's the same sound recording. When you hear the music, when you hear the remix, it's going to automatically trigger the original or master recording back to you. So there's no question that it's a duplicate or a reproduction of an original or master recording. So that's a copyrighted work. And there's no question that he was upset and did not like the fact that Mr. Roberts reproduced that copyrighted work. Well, reproduction is one of the exclusive statutory rights granted to a copyright holder. So we were talking about a copyright case in this instance. But for those who continue to talk about social justice, because the creative talent or the creative artistry in my case works both ways. It actually benefits everybody. It benefits Mr. Roberts and those artists who do decide to freely and want to creatively produce remixes that has indeed been commonplace, specifically in hip hop itself. So for those artists who have enjoyed doing sampling, and I'm not suggesting or encouraging or condoning that, you should always get a license. When in doubt, get a license, don't sample. But in the unlikely event you choose not to get a license, does this case now support the notion that it's okay to sample in a limited context? Limited context. Note the Second Circuit said that it didn't implicate contextual implication of endorsement. So you still have to be careful. In other words, but let's flip the script here. Let's speak in full support of someone the likes of Mr. Jackson. And Taylor Swift is struggling with this issue right now, where yes, you were under contract when you first started, you blew up, but in that process, you were subject to a contract that did establish a work for hire. And we know historically from Professor Mtima's presentation during the lunch hour that has disproportionately disadvantaged musicians of color. No question about that. And on that topic, if you haven't seen it yet, plug for Netflix, I would encourage you to watch the Lion's Share Remastered documentary. It's a documentary on Netflix called The Lion's Share, and it's about all of the varying copyright implications and problems dealing with The Lion Sleeps Tonight song that we obviously know from the Lion King soundtrack, but that's not how the song actually started. Another day, another topic, another seminar. So getting back to this artistry aspect, this creativity aspect, and why actually Mr. Jackson has stumbled upon what is going to continue to be a problem for companies and other industries that use music licensing all the time. The Second Circuit, impromptu, I didn't argue this. It wasn't necessarily a question that was even asked per se. It wasn't even an argument that his lawyers were trying to make. But the lower court's ruling, when they granted preemption, the lower court just said, well, you contractually surrendered your right of publicity because you are work for hire and you agreed that your name, image, and likeness could be used in advertising in connection with the song without necessarily needing prior consent, at least for videos and other major music distribution mediums. What the Second Circuit Court of Appeals said, and you have to read it in greater detail because, again, it's 66 pages, so you really have to pay attention to the whole opinion. What the Second Circuit said was, well, we agree with the lower court on on copyright preemption, but not for the reasons that the lower court asserted, which dealt with contractual. It was a contractual-based copyright preemption. What the Second Circuit Court of Appeals said is Mr. Jackson actually did not contractually surrender his right of publicity. He only did that within the scope and within the term of his agreement itself. Well, his recording artist agreement with Interscope expired. It expired, I think, 2013, I want to say, maybe even slightly before that. So his actual agreement and what he waived over, per se, expired long prior to Mr. Roberts' subsequent remix. And the court, I want to read for them again, because this is really important. It says, upon the expiration of the recording artist agreement, Jackson recovered a shared interest in his right of publicity and is not contractually precluded from bringing this right of publicity claim. What did they just do? My goodness. No one's reporting about this. I'm giving you information that is still kind of a secret right now. It's not getting picked up. I'm obviously not going to talk about it too much publicly because that could carry a different adverse interest for me based on the client that I represented. So, but the Second Circuit basically chose to make contractual interpretation in which it didn't need to, but it chose to anyway. So this was a gift for creative artists here. The Second Circuit is saying, well, your right of publicity that you signed over, that was only during the scope of your agreement. That interpretation, respectfully, is wrong because there is a survival clause. The survival clause always trumps even if your actual duration under the agreement expires. That's how it's been done in the music industry for decades. That's how it's always been, and that's how it continues to be. But if I'm representing Mr. Jackson or the likes of a Mr. Jackson or Taylor Swift, I'm honing in on that indicted language, and I'm taking that all the way home and arguing right of publicity claim, saying that, well, that was only something I signed over within the scope or during the time of my agreement. It doesn't still last now. So it's like holy, you know what, that indicted language is going to slowly but surely get picked up. And I think many media companies or corporations for that matter who have to clear music, they're really going to have to start to consider not just clearing music and getting permission from the copyright holder or the publisher directly, but they may even have to possibly go directly to the performer as well to get a granted right of publicity. And you can imagine the number of collaborations and songs that feature multiple artists. So go figure that out. But Ron and I wanted to make sure you were fully immersed in getting an update, both from the sports side as well as the entertainment side. And as time permits, it looks like we've got 13 minutes left. We obviously entertain any questions you may have.
Yes, thank you so much for those presentations. They were both wonderful. I actually do have a question for you, Mr. Jonathan, from one of our guests. They said, what about the fact that it was a mixtape and not a commercial album? Does that have any difference in the implications of the results of your proceedings?
Yes, I mean, that worked in Mr. Roberts' favor because we made an emphasis on the fact that this was not a commercially released album. And that this was more of a creative freestyle cultural commentary aspect. And we even hired an expert, a gentleman by the name of Bob Cohn, who has written several treatises, Cohn on music licensing, in which he wanted to, we worked with him on going so far as to make a First Amendment argument that an artist's ability to freely include his own lyrics, even if it's on a sound recording that was not original, he's now created something original based on his own lyrics. And what he was talking about, some could argue, is dealing with cultural commentary. So I think the contextualized nature of the facts in my case certainly helped to kind of delineate a distinction there. And even the Sony Laws versus Music, the Laws versus Music, Sony Music case, that actually was in a commercial context. So you can even have preemption in the commercial context. But that was certainly what Mr. Jackson's lawyers were arguing, that it was so commercialized because he still mentioned Mr. Jackson, at least in the track title. And he also mentioned in his lyrics that he was having another album that was coming out. And so because he did that, in their mind, that was the equivalent of a commercial promotion.
Thank you. I do have one more question before I move on to Mr. Ron. Do you believe that this will create a wave into the other circuits when they see the addendum, at least for the progressive circuits that are handling these type of issues?
Well, you're having a developing split in which you have the 8th and the 9th circuits in favor of preemption, even in commercial contexts. So too now is the 2nd Circuit in accord with that. But the 3rd Circuit has stated differently. And I believe the 7th or the 10th Circuit has actually, they actually have decisions that have ruled both ways. I actually do not believe the 4th Circuit has made any ruling at all on this particular doctrine. So I'd say give it another year or two and we'll find ourselves waiting to have the U.S. Supreme Court weigh in.
Okay, and then for Mr. Katz, what do you think of college athletes? What do you think they should know, or maybe the graduating athletes should do in order to push the narrative for the profit off of their likeness?
Well, I think athletes are in a very difficult position. They've worked their whole lives, spent many, many hours developing their skills, and they are very dependent on their coach or their athletic director. So you don't really see many athletes acting out because they know that they can be shut down. I mean, unless you're a superstar like LeBron James, if you're just an average professional athlete or average college athlete, your career can end if you step out of line. There has been one exception to that in recent times, and that is a few years ago at the University of Missouri, the football team said, like on a Wednesday, we're not going to play our game on Saturday. And that was power. That was real power because you had TV waiting, you had contracts, you had all sorts of things, and they got their way. And I think if we see more things like that, there will be progress. But I think right now you're going to have to depend on politicians like Senator Blumenthal, and it's very slow. It's very slow. There's a lot of NCAA has a lot of money to spread around, and they've been there for a long time, and they've been very successful in creating this myth of amateurism, which really it's a myth. It just does not exist. As I said, they're the most powerful, clever organization in the world because we're talking about this. We're talking about how a person can use their own name. I mean, really. I don't know what to say. I'm speechless.
I do have a question for both. For those who want to continue to stay updated about the right of publicity when it comes to entertainment or athletics, who should they follow or subscribe to in order to get this information?
So I was actually asked this same question yesterday. I was a guest lecturer with Professor Jaya Thomas, founder of the Diverse Representation Network, based out of Los Angeles. What treatise or what sources should we look at to keep up to date on right of publicity law? And unfortunately, by the time the book gets printed and published, even if it's an online version, it's already old news. So if I'm a student, I'm paying attention weekly, actually, to case rulings, because that is the jurisprudence of what rules right now. So IP Law 360 has a daily update of right of publicity cases that come out. Other publications, Thomson Reuters, Westlaw, Bloomberg, Legal News even, they're giving updates on right of publicity laws, including what Ron was referring to in terms of the NIL state-by-state legislation that continues to develop.
I would recommend that students join something called the Sports Lawyers Association,
Yep,
which has over 1,000 practicing lawyers in it. And they also have a section for students. They have a writing contest for students. They give special rates. They have an annual conference. They give special rates for the students to attend. It's a great place to network. One question that I'm always asked is, how do you become a sports lawyer? And the answer really is network, network, and network. That's really the only way to do it, because your placement office is not going to have, the Washington football team or whatever they're called these days doesn't come to your placement office. They don't come to anybody's placement office. So, and they have publications that come out daily, 3 or 4 publications that come out every day, and they cover this stuff. I mean, this is a very hot issue, because basically, this is like Russia in 1917. The NCAA is about to fall. They are about to fall. They cannot sustain themselves in this social justice context. And insofar as organizations like the IPSJ has contributed to that, I say wonderful, but God bless them. This won't last forever, but it does take knowledge. And most of the exploitation, as I say, has not been really exhibited to the public that much. And the irony is that the most powerful people, the athletes, are also the least powerful people, because they know that they're one step away from being blackballed.
All right, and to finish out, oh, I'm sorry, go ahead.
No, I just wanted to jump in to add what Ron was saying about just this systemic or seismic impact of name, image, and likeness issues. I think it's a bit naive to think of right of publicity law as just a part of the sports industry, or something that's just a part of the entertainment industry, for that matter. I mean, name a Fortune 500 company that does not have some sort of advertisement or endorsement deal or some other advertising that's tied to sports. Those deals can become quite subject to vulnerability based on name, image, and likeness issues with players who may or may not, have fully agreed to certain contractual waivers that even the Second Circuit is acknowledging has its limitations. And the same is true for entertainment. I'm doing some work for a Fortune 500 company right now dealing with music clearance because they have an internal portal that is playing music internally. So it's not publicly available, but should some internal employee haphazardly or mistakenly find an open source loophole and leak that into their Facebook page, well, then you've got music that may or may not have been licensed that's out there playing. So there are companies that are dealing with music issues all the time, even if they're not directly an entertainment media giant. And we got to get over this misnomer, this myth that somehow certain issues like right of publicity are only specific to sports or entertainment. And that's how you end up becoming a quote unquote sports or entertainment attorney. You're really just doing the legwork, the SME work, the subject matter expertise work. So if you like tax, be a darn good tax lawyer and you'd find yourself some sports clients. If you like bankruptcy law, be a darn good bankruptcy lawyer and you'll find yourself some entertainment and sports clients, because some of them, respectfully, go bankrupt. So not talking about Mr. Jackson, of course, but just always find the way in which you can get in where you fit in, and you'll find yourself doing more than what you thought initially.
I just want to add to that and say that the NIL issue for the NCAA is really the keys to the kingdom. Because think about it. Let's say I own 10 BMW dealerships in the Bay Area, and I want to bring the best college quarterback to Stanford. I say, fine, I'll pay you a salary of $1 million a year. They say, oh, no, you can't pay salaries. I say, okay, well, I'll give you $1 million a year to endorse my car dealership. Does the player care? The player's getting $1 million. He doesn't really care what you call him. So basically, it will be the end of amateurism as we know it. And of course, nobody knows what amateurism is.
Except for the NCAA.
No, well, yeah, that's true. They know whatever they're thinking right this second. That's it.
Thank you so much. I have one last question. So I have a guest who's asking, when it comes to the right of publicity in the context of historical figures, what makes a person a historical figure? So for example, like the Parkland High School shooting, who later become gun advocates, are they the same historical figures that we might represent in maybe movies like the Judas and the Black Messiah's film? How does right of publicity work for historical figures, and what constitute as them being considered one?
Right. So, go ahead, Ron. Oh, you want me to?
Go for it.
So yeah, I mean, right of publicity law does not discriminate. We all have a right of publicity, whether we're a historical figure or famous figure, celebrity or non-celebrity, boring IP nerd like myself. I think I maybe have 100 followers on Instagram. That's about it. I don't have many friends. So you don't have to be famous or historical in order to be able to assert, right of publicity. But I mean, I do think that without question, many TV, film, entertainment producers, when they're trying to evaluate how best to clear rights and the ability to have a production of a person that has long passed away, do you need to get their permission from their estate? Do you need to the extent they're still alive, get their express permission? We have seen stories and articles in which either the estate or the person who was portrayed negatively, him or herself, come out and speak ilk of that movie. But the First Amendment is a powerful area of a shield, let's say, for media and TV and film producers. So long as your production is factually supported by the documentation that you can find, objectively, reasonably valued documentation, it's very difficult. It's like trying to sue Google for copyright infringement, and we know from the Fourth Circuit's Rosetta Stone case how difficult that can be, or Microsoft, let's say. I'll be very respectful here of Mr. Bingham, and this is a Microsoft event, so, and my wife works for Microsoft, so shame on me for not saying Microsoft. But see, I know Microsoft is not even going to put themselves out there where they would even be subject to something like that. But that's just my 2 cents. Ron?
I think we're out of time, so I would just.
Oh, there we go. Saved by the bell.
Okay, well, thank you so much for being here. We really appreciate your attentiveness to the right of publicity and keeping us informed. I don't know if Tessa wanted to close it out.
Yes, thank you, Ron. Thank you, Jonathan. And thank you to all of our attendees. I know I learned a lot during this discussion, and that's even with my studies. So thank you. And yeah, now we can get ready for increasing investor diversity, I believe is up next.
Thank you.